Hey guys, just waiting a couple minutes to see how long it takes to get everyone in here. Sorry, I'm a little bit late. Oh, one person. 2 people. Yeah, I threw everybody off. I know I said I would start at 6:30. I just, life. That's all I can say. Hi, Allie. Yeah, it's been a bad week. That's like over a bad week now. I didn't actually get as much done on this as I wanted to. It's just story of my life lately. So I'm gonna go over what I can and talk about some of the case law that I have had a chance to look up. I haven't had a chance to look up all of it though, and some I might not even, because it's not that big of a deal. I'm kind of just whatever about everything lately. So I hope everybody's having a better week than I am. I know I'm always talking about what a hot mess I look like, and I totally do today, and it's my daughter's fault. She's in town from Syracuse for spring break, and she came over last night, and then she stole my straightener. I was looking for my straightener to straighten my hair, and it was just gone. Might have mentioned that you took it. So yeah, so this is what happens when that happens. So, gotta love kids, I swear. I actually told her that, and she said that I could tell everybody that she sucks. So yeah, my daughter sucks. She doesn't though. She's totally awesome. Okay, let's see how many people I have. Okay, well, probably enough to get started. Let me take a drink. Again, sorry that I'm a little bit late. Hopefully it won't take too long. I will be joining Eric Hosey and Travis when I'm done here. Since I'm a little bit late, I probably am going to try to not take too long, since they're going to be waiting for me to get done before we can do that video. So hopefully it won't take me too long. Okay, so today, the first thing I wanted to talk about really quick was the situation with e-filing, because everybody obviously was a little bit confused yesterday why the filing didn't happen. And I kept telling people it did happen. Trust me, it happened. It was the correct due date. I know people kept changing the due date, thinking like, well, no, it's due Wednesday or it's due tomorrow. No, the 11th was always the due date. There was no doubt about that. When you e-file in the circuit court, you actually have until midnight on the due date to file. I don't necessarily think that Kathleen waited that late to file, but she probably did wait late in the day, possibly after the clerks had already left. Now, when you file with the Court of Appeals or the Supreme Court, when you e-file with them, it has to be by the end of business day. That's why it gets a little confusing. When documents are electronically filed, they are not just automatically sent out to the public. The clerk has to approve them. They have to look at them, make sure they're in the proper form, that signatures are there and everything, and then they upload them. And this morning was actually kind of funny, because I just kept getting notification, because each exhibit was uploaded individually, and so I kept getting different notifications. And so, yeah, I kept telling people that, don't worry, she filed it. It sucks that it came in so late that they didn't get to put it on the docket, but it will be there in the morning. Don't worry about it. And it was, and as you can see from looking at it, the date is March 11th, which was yesterday. So that is when it was filed. So just want to clear that up. And this happened once before, and I kept trying to tell people that. I'm like, this actually happened one time before. That time, I don't remember which motion it was, but that time she did on a Friday. And we had to wait all weekend to see it. So at least this time it wasn't like we had to wait an entire weekend. We had to just wait one day, not even a full day. And already people are talking. Hey. Oh, thank you, you guys. Hope all is well. Hope all is well. Yeah. Yeah, and she had a straightener at your house. Yeah, I could tell her that, and then she could have actually gone over there. Yeah. And thanks again to everybody who was understanding about my taking a little bit of a break and needing some time for my husband's situation, and so he could be on the mend. He's doing much better. Well, not much better, but he's doing better. He's mobile now. He can at least move. but the ribs are still sore. So it'll be still a little bit of a process. Ribs take a long time to heal. So, but again, I appreciate everybody's patience with me. Okay, hi Tina. I don't usually get to see you during the live. You're always working. Okay, so now that I got that done, a lot of what's in this motion has been covered over the last month. Okay, I've done it in probably 3 or 4 videos, maybe more. So I don't want to rehash the same stuff that I've gone over, many times before. If you want to learn more about young blood and the preservation statute and what it means and what needs to be followed and what the rules say and what, all that stuff, just, go back and watch some of the previous videos on that, because I don't want to talk about it all again, because I probably spent hours already talking about it, and I'd rather move on to some of the new stuff that was added. Let's see. Okay. I'm just going to go through this a little bit. Okay, so in the beginning of the motion, in the introduction, Kathleen is setting up what is probably the most important part of this entire thing. And one of the hurdles she had to overcome is that the preservation statute says that the bones have to be identifiable as the victims, that you have to preserve anything that belonged to the victim. This obviously caused a problem because in the trial, they said that it was just possibly hers, that it wasn't necessarily hers, and it definitely wasn't definitively hers. And that would be a problem, because by the letter of the law, it would be very easy to say, well, it wasn't identifiable as hers, so therefore no violation. And that was going to be a problem. The state was nice enough to provide all kinds of other stuff that came along after she originally filed that helps with that argument greatly. She mentions them repeatedly, and I will go into more because she mentions them again later. But essentially, the ledger sheets and Dr. Eisenberg's report, suggests that they're human, that they were human. Not just that they were possibly human, that they were human. And that is a very important point to make, because if she wants to win on that issue, she has to be able to say, hey, they thought they were human. So, and if they were human, they think that they gave them back to the family. So therefore they must have thought they belonged to Teresa. So it's very important that she now has documentation from the state showing that they knew these were human bones, because that is a big part of trying to satisfy that part of the statute. Because otherwise, as long as it's still not identifiable as Teresa's, but it's still a much stronger argument knowing that they gave what they knew to be human bones back to the family. And then that goes back into the whole thing with the pelvic bone that I said a while ago, that was the most important one because it was used during the trial. They can't say that it wasn't important to the defense, because it was. So the fact that those ledger sheets became available, or we got current copies of them, is important because it shows that they knew that they were human when they got rid of them. And I'm going to go off on these tangents, and I don't want to do that. I need to sit back a little bit. Sorry. I fell on the ice and hurt myself in a sensitive area. It's hard to sit, so I have to sit back a little bit more than normal. Okay, I'm gonna look and see if there's any questions before I get going. I don't know, Eric. Why aren't you getting notifications? I don't know. Facebook is dumb. I still don't get notifications when people join the group or submit posts, so I don't know why that is. Okay, so this is the stuff that she's going over right in the beginning, is that she first is establishing, I kind of jumped ahead a little bit there. She's first establishing how important it was to the state's theory and what they presented at the trial that Teresa never left the property. Okay, it was a huge part of their case that she was killed either in the trailer, in the garage, and she was burned behind the burn pit. That yes, some bones were moved, but they were only moved from the burn pit to the burn barrel. They weren't moved off of property. That was a very big part of what Kratz said during the trial. And so she's claiming it as being fraudulent information that was presented to the jury. She's adding an extra component now. Let's see. Because she's saying that not only this, and she kind of jumps back and forth, so that's what I'm doing too. But she's saying that not only did he want to like draw attention away from the fact that there were human bones found in the quarry, but that he knew they were human. Okay, and I will get to that more in a little bit later. Now, right in the beginning here, this is the first time she brings up the April 4th, 2007 preservation order that was made by Judge Willis. There are a couple things that I have issues with in this motion, and this is the biggest one. I don't like it. I don't like that she keeps bringing up this preservation order, because the order was very specific. The preservation order was that they were supposed to preserve any samples that contained Steve's DNA from the RAV4. Okay, the blood samples that were determined to be Steve's DNA from the RAV4, and any material that was sent to the FBI lab for EDTA testing. Not anything sent to the lab, anything that was sent for EDTA testing. It was very specific. And those items she has already received and tested. And yet she keeps referring to it as this was an order saying that they had to preserve all this stuff. No, it isn't. It isn't, and that's not, it never was. And I don't know why she keeps saying it. And she says it repeatedly in this motion. And it drives me crazy because I don't think she needed to. And the reason why it drives me crazy is because the last thing you want to do is hand the state a win on any point, whatever. And this is a slam dunk win for the state on this point. So why draw the focus to an issue that you know that they can argue and win when you don't need it? There's enough there to be able to show that they improperly dispose of this evidence without having to rely on essentially misrepresenting what this order said. I wouldn't like it if the state did it, and so I can't like it if she does it. Okay, and I hate it, and people will be like, oh, you know, like you're being so mean, whatever, you hate KZ. No, I don't, but this makes no sense to me. Read the April 4th order for yourself. It is very clear what is covered under that order. It is not a blanket preservation order for all biological material, and it is not a blanket order saying that any testing on anything from the case can be done in the future. It is not that. So she needs to stop saying that it is, because, like I said, it's just handing the state a win. When the state files their motion, they're going to be focusing on that like crazy because they want to make it sound good. And why even give them that opportunity? Why open that door for them? That's the part that I don't understand. It's like they're going to lose on a lot of these points. So why, like I said, why give them an argument that they can win? Drives me crazy. I just don't understand it at all. Moving on, she brings on up the fact that the state's misrepresentations to the jury weren't discovered till 2019. She's saying this again because she really wants to make sure the court understands this is truly newly discovered evidence, because that is a big part of a 97406 petition, that it has to be newly discovered evidence. So she's just making sure, in case you were sleeping and you haven't been paying attention for the last several months, or last month for sure, this is all new stuff. You know, the rapid DNA testing, and then this finding out about the ledger sheets, finding out about the case report pages that were missing. This is all brand new information to me. Okay, so like, just in case you guys are like not paying attention, you know, like this is not old information. This is new. And so I want to make sure you know that, so that you can't say that, you know, it's frivolous or that it's not supported by the record, and all the reasons why you can deny 97406. While I'm saying that, I think people know this, but I should probably mention it. This is called a supplemental motion because it is supplementing the original petition. It doesn't matter that the original petition was filed in June of 2017. This is still considered to be a part of that petition. Okay, it's not a separate filing. It's considered a supplement to that filing. So this is still all part of the original 97406 action. Again, I think that's something that people know, but some people might still be confused by it. This is something that she's adding. So when all is said and done, if you talk about the petition, it would include the original petition that was filed, again, in June of 2017, the motion to add the CD to the record, and this. They're all supplemental filings to the same petition. So it's the same action. Let's see, now here they go into procedural background, and that's the area where it's talking about everything that happened in the Court of Appeals ever since she filed the motion to test the bones with the rapid DNA testing. And again, that's been covered repeatedly. So I'm just going to blow past that real quick. And I know there's probably other specific things in here that I would like to talk about, but I just don't have the time right now. Okay, so we're going to get to where she's talking about Dr. Eisenberg, the state's expert regarding the bones. And this is what I talked about before. I kind of jumped ahead on this one, but this is what I talked about before, where she is establishing that Dr. Eisenberg's reports on some of those items, you know, she listed on her report, which I don't think we had before, right? We didn't have that before. That was new, at least for me to look at, I think. Maybe not, I don't know. But there, she's kind of pointing out that her own report said that these were human. Some of these bones were human that were found in these quarry piles. They weren't all suspected human. They weren't all possible human. There were some that were strictly listed as human. And then she goes into the state's illegal transmittal of the bones to the Halbach family. And again, that's been covered in previous videos. And then she talks about how the current post-conviction counsel signed an affidavit saying that they never had those those case report pages or the updated evidence ledger pages. So a lot of this is pretty straightforward. It's just kind of rehashing what she already talked about before. Now, this is where we're going to get into the preservation statute. And again, we've talked about this before, but one of the things that Kathleen mentions is that the 968.025 statute does not provide for a remedy. And that's problematic because it's like, well, even if it's violated, what's the punishment? What's the recourse? What's the relief? And it's not defined. So she's essentially saying that, yes, it's up to the judge to decide then, you know, it's to use their, to fashion some kind of remedy. And she's describing it as a pro se violation of due process. Okay, when you say pro se, it just means it's not specifically, it's not a bright line rule that it's a due process violation, but it's in the same vein as that. So you're saying that it's a pro se due process violation. You know, it's like, it's very similar to what would happen if it was violated under Youngblood, which would be a due process violation. So she's saying that this should be considered the same type of thing. So essentially she's just saying that if you are going to say that destruction of evidence under Youngblood is a violation of due process, then you should also say that a violation of a preservation statute is also a violation of due process, even though it doesn't say that in the letter of the law. She also mentions in the footnote, as we've talked about before, that there are no published opinions from a Wisconsin court that address a violation of the statute. And again, it's been around a long time. I know they're probably missing questions, so let's go. How long do the court have to respond to her? I will get to that. Well, you know what? I'm going to cover it now because I don't think it's in my notes, so I don't want to forget. Okay, I actually just talked about this with Travis before, so that's why I told him then. I'm like, I'll have to remember to talk about this, and then I didn't put it in my notes. So I'm glad you brought that up. Okay. When it comes to a petition, a motion like this is not just a motion, it's also considered a petition. When it comes to a petition, the court or the judge, okay, let's say the judge, the court, but whatever, the judge is not required to get a response from the other side. If she's going to deny it, like she has in the past, she does not have to get a response from the state. But if she is going to grant it, she does have to hear from the state. And if you remember from Brendan's case in the U.S. Supreme Court, the same is true there. When you file a petition for a writ of certiorari, they have to, the state doesn't have to respond. They did in Brendan's case, but they didn't have to. But because a lot of times it's just a lot of time, a waste of time and resources if this ends up being like something that has no merit and the judge is going to dismiss anyway or just rule against anyway. So they wait to see if the judge is going to actually entertain this motion and request a response from them. And then they'll get to work responding. But they don't have to. Now, last time on the CD issue, the state actually wrote a letter to Judge Suckwitz saying that they intended to respond. Even though they did respond, she still was under no obligation to consider it unless she was planning on granting the motion. So I said, you don't have to consider the other side's argument if you're going to deny, but you do have to consider if you're going to grant it. Now, she would be the one that would set a due date for that. If she wants to hear from the state, generally 30 days is going to be the norm. This time they only gave Kathleen 14 to file this, so who knows? You know, they might be trying to keep it on a shorter schedule, but we should see something from the judge very shortly. If the state hasn't already notified or doesn't notify her that they are going to respond, then we should see something from the judge, hopefully, asking for a response, and then she would determine the due date of when that would have to be filed. So we don't know right now like what time frame we're looking at, but again, it shouldn't be more than 30 days. I mean, Kathleen only had 14 to put this together. After that, if you remember from the CD issue, the Court of Appeals gave 60 days for a decision. This time they didn't give a guideline. I would think that 60 days to decide whether a hearing should be granted or not is sufficient, but technically the judge has 90 days to do that. They can take longer if they need to, but there's no reason they take longer than 90 days to decide a supplemental motion. You know, it only took her a little longer than 90 days to decide the entire original petition, and they had a lot more information in it. So I did want to bring that up before I forgot. Why wouldn't they test or keep the bones from the quarry? It could be Teresa's, but who knows? Well, yeah, that's the question at hand here. It's like if it's human, it doesn't matter if you know it's Teresa's or not. If it's human, you should be keeping it. Somebody should be doing testing on that because that could be either Teresa, but it could be somebody else too. Why do you not care that a human being, there's a human being's bone found in a quarry? It just in general, it's just really stupid. Okay, it says that Kathleen makes a statement that Teresa was placed in the Dassey burn barrel and taken to the gravel pit after sundown and burnt. Other than naming a witness who smelled the fire, she didn't back that up. Should she have done so? No, she doesn't really need to. I mean, this is not a situation. If she was during a trial, if there's a retrial, she'd probably have to find as much evidence to substantiate that claim as she could. But here, we're just deciding whether it was a violation for them to get rid of it. So, so she just needs to, give some support to that argument that that it could have been, that she could have been killed in the quarry. She doesn't have to make a really strong case for it because we're not at that point yet. That would be something that would happen later on if, he's granted a trial. Then she can make a really strong argument or try to make a strong argument that she was killed in the quarry and not at the salvage yard. But for right now, no, she doesn't really need to make a strong argument for it. She just needs to give some suggestion that it could have happened that way. I don't know. Kim, I'm not sure what you're talking about. I'm sorry, when you said, so basically you're saying she screwed herself. I don't know which part you're referring to. I wish my kids would go to bed. Jenna's saying, what about her saying that the bullet was hers and it really was actually paint? Again, that's something that would have to be addressed at a new trial, or can be addressed by the Court of Appeals. That's something that's already in front of the Court of Appeals, that issue with that scientific testing. Okay. Eric, why suggest she was killed on the property? Who suggests that? Are you talking about Kathleen? Like, why is she saying that she could have been killed in the quarry and not just somewhere else? Or are you talking about why is the state saying she was killed on the property? Sorry, guys. My brain's probably not functioning on all cylinders, so I'm not quite understanding all the questions. It's hard, too, when I'm talking and I've already moved past the point that I don't know, but I'll get back to that. Okay, so then after that, where we talked about that there's no remedy, she goes more into Trombetta, Youngblood, Greenwald, covered it like crazy in a previous video. If you really want to get into the real nitty-gritty of Youngblood, and watch my video that was exclusively about Youngblood. I covered it in depth, more than anybody ever wanted to know about that case. Okay, and she talks about, again, about due process. This was all stuff that she touched on, maybe not as in depth, but in her original motion to remand the case. So I don't want to keep going right through that again. And then she brings up the assumptions that are made by the preservation statute. I don't necessarily agree with this, but I know where she got it from. She got it from a law review article that was actually written prior to the statute being changed. When that law review article was written, I mentioned this once before in another video, but when that law review article was written, that was when the statute still said they had to keep all biological material, not just ones that were identifiable to the victim. So that's where she gets it from, and they're making these assumptions. I don't necessarily think that's the strongest part of the argument. When it comes to law and assumptions, they just don't go hand in hand usually. So that's why it's not, I don't mind it. There's nothing wrong with it at all. It's just not my favorite part of the argument that she's making. Okay, so here she says that the state was aware of the apparent exculpatory value, materiality of the bones prior to their destruction because of the pretrial FBI examination, trial stipulation, and April 4th, 2007 order. Again, the April 4th order had nothing to do with the bones. It said nothing about bones, nothing, anywhere, whatever. So why does she keep bringing it up? Sorry. This part I actually draw a little triangle around here, or rectangle, triangle. Post-trial, the state was aware of the apparent exculpatory value and materiality of the bones prior to their destruction when the trial court entered an order on April 4th, 2007 for the preservation of blood evidence. Again, blood evidence and independent defense testing. Again, the exculpatory value of the bones and the materiality of the bones has nothing to do with that April 4th order. I do not know why she keeps doing it. Again, expect the state to just hammer at that repeatedly because she keeps bringing it up. It's like, that is not what it says. It has nothing to do with it. And you can't say just because he ordered preservation of something specific means that it was, like I said, it was a blanket order. But here she's specifically saying that the state was aware of the value because of this order. No, that's not what it says. Why are you? Sorry. But she said this order contemplates and allows future DNA testing by Mr. Avery. Yeah, on the blood evidence in the RAV and the EDTA stuff. That's what it allowed for, not for everything. In its order, the trial court gave Mr. Avery the opportunity to, at any time, submit items of evidence for DNA testing. No, it gave him the opportunity to submit the blood evidence, and that's, for testing. It's not any items. It's just those things. Both the apparent exculpatory value and materiality of the bones was established by the April 4th, 2007 order. Deep breath. Okay. I think it's such a good motion other than that. But why? Why? I don't understand it. To me, it's just, and especially since it's a black and white issue. That order is in black and white. What's allowed? So I don't know how she thinks that that's a good argument for her. I just don't understand it. No, would she call Brendan if there's a new trial? I think I saw her mention it once, but I honestly don't know if she would. That's always tricky. Yes, you can call Brendan in and he could say that I was with my uncle and neither of us killed Teresa Halbach, but that also brings in Brendan's confession. So that's the reason. There's kind of a double side to that. She says about Teresa being in the Dassey's burn barrel. Oh, you mean why does she have her going in the burn barrel? Maybe that's what she thinks happened. I don't know. Maybe I'm still not understanding the question. But she's saying that she was transported in the burn barrel. Well, I can also say why she's saying that because of who she suggested, her theory of who the killer may be. I'm not saying any more than that. I don't want to go into that. So what has to happen to let KZ have access to the RAV and bones in custody? A new trial. If the Court of Appeals reverses Judge Suckowitz's order, at that time she may be allowed to do more scientific testing, but for sure if there's a new trial, she can test anything she wants if there's a new trial. Anything that's still available, she can test. But she can't do it mid-appeal. She just can't. And this is under limited remand, so she can't make that demand now. There's been a lot of talk, speculation about replacing the judge. Oh yeah, I'm gonna get to that. You're not gonna like it, but I'm gonna get to it. Yeah, one of the things that we're saying, someone's saying like for option 3, if bones were buried, they degrade faster than buried. You guys are not helping me out with these questions. Then what she's saying is that yes, they're saying that if the bones had been buried, they would have degraded faster than if they had been kept in evidence because they would have been exposed to elements. Whether that's true or not, I really don't know. Do I like the word commingling? At first I was like, commingling? What is commingling? Commingling. What is there? Yeah, I don't know. It looked weird. Did she put 2 M's in it? I don't know. She did, but it took me a second to realize what word she was using. That is about stuff. Thanks, Travis. Why wouldn't the April 4th order include all biological evidence? Seems like it should have been because the defense never asked for that. They did not ask for that. They asked if this was going on when all of the arguments were happening over the EDTA testing and whether it should be allowed or not. The defense was losing on that point big time. They shouldn't have, but they did. And so since they did not do any testing of their own at that time, they thought the EDTA was a huge blow to the case. So they specifically asked for anything that was of Stephen Avery's that was inside the RAV4, the blood evidence, and anything that was submitted for EDTA testing be preserved so that they could test later when EDTA testing possibly became more reliable, became, a better test. That's all they were thinking about. Yeah, they should have asked to preserve more, especially that pelvic bone, since they made such a big deal about it during the trial. The defense did, but they didn't. They only asked for this EDTA stuff to be preserved, and that's what the judge ordered. That's why. It wasn't really up to the judge. He just was granting what they asked for. Okay, you're saying, you guys are jumping ahead of me as usual. You always do this to me. I didn't see anything other than a second voicemail message for KZ saying they did give bones back, but perhaps still have what she needed. As she hasn't listed what was returned, can we assume the state hasn't provided her detailed list? I don't think we can assume anything. I don't like to assume anything. Again, you got ahead of me because I was going to address that. So I'll get to it in a minute. Thanks, Maureen. Dana, yeah, she should have cited Fallon's letter where he states that 8675 was apparently relevant. And I agree. I mean, I sent her that. I know some people sent it afterward, but I mean, I sent her that right away. And just saying like, yeah, he himself is calling it apparently relevant. So he can't say that it's not important. I was expecting that to be part of it and her to add that exhibit because she was kind of right on the border of mentioning that. And instead she kept talking about this order that doesn't say what she says it says. But yeah, I thought Fallon's letter was much more, a much better argument because those are his own words. And people hate it when you use your own words against them, but he did. I mean, he said that they had some apparent exculpatory value, albeit minimal, but so what? Doesn't matter. It doesn't say in the statute whether it has to be a little, exculpatory or a lot exculpatory. It just says, is it apparently exculpatory? In this case, she's going with the potentially exculpatory because apparently is kind of a high standard. That's when the test results themselves could determine his innocence. That's usually what apparently exculpatory would be. Potentially exculpatory means these test results could result in different avenues that could prove his innocence, but it can suggest his innocence. That's what potentially means. She did put 2 M's in it. Okay, thank you. Then it's not just me because I was like, commonly. Thanks, Julie. I'm glad you remember. Maybe she'll save Fallon's letter for after the state responds. Well, there'd be no point in saving it because there's no guarantee that they'll still get a response for the state. I don't know. She has her reasons, I guess, but I was surprised that wasn't included because I thought that was actually a pretty strong argument. Okay, we're still in Trombetta here. And then she brings up the April 4th preservation order again. where she says that both of these violations mean the state acted outside the scope of its normal practice by destroying evidence it knew had to be preserved in compliance with the statute and the April 4th, 2007 trial court order. It's like, just stop bringing it up, because that's, I mean, to me, it's that the state is going to be able to not address a lot of these things because it's going to be able to focus so much on this order that, and yeah, a judge should be able to see through that, but I don't trust this judge. Don't give the state any reason to look good, or look right, I should say. Let's see what we got else going on here. Okay, here's the phone call with Fallon. And yeah, for those of you who haven't listened to the phone call, it's in the link that I gave from the Work with KZ website, and Kathleen actually has it on her website now too. But in the voicemail, yeah, Fallon says that they gave many bone fragments were returned, but he also said that he and Norm Gahn on Friday, whenever, let's see, that was, we're going to go up there and take an inventory of what was actually there. And he said he'd give her a jingle after that. Nothing is mentioned of that. So I'm very curious if he ever gave her a jingle, if he did inventory them and what was found there. I'm not really sure. I don't know. I haven't heard anything yet. So that's something that would be really interesting to know. Like, because he was saying, like, well, I think we do have the ones in question. Yeah. Doubtful. I'm thinking if they called her and said that they had the ones in question, that she wouldn't be filing this right now. So I don't know. But, you know, that might have to wait for the state's response. That might be something that would be in their response. And then she mentions the affidavits of her experts. And again, it's just read through it, skim it, if it's kind of dry material, because we've seen a lot of it before. Some affidavits are new, but they're essentially saying the same thing. Again, with Dr. Selden, he's again just referring to the DNA testing, the rapid DNA testing, how it was only recently approved by the FBI, again, making it newly discovered evidence, but that they still should not have disposed of the bones because technology is always improving, and there's no reason to think that they wouldn't have been able to test these. And so that's just something he's talking about again, of what the rapid DNA process is, what it entails. She talks about PLUD. Oh, that's just talking about basically the standard for newly discovered evidence and be granting a new trial under a 97406. Kratz's knowingly false representation during closing arguments. Okay, this is what I was talking about way before in the beginning. I jumped way ahead. Where it's one thing that now the evidence ledgers showing the bones were returned were clearly well after the trial. The CASO report pages were after the trial. If she wants to nail Kratz for something and talk about giving false testimony, she had to have some corroboration somewhere that these bones were human. And that's where Eisenberg's report is important, because when you look at that report now for 8675, which is the pelvic bone, for that one, you know, she has a question mark next to it and says it's a bone of unknown origin. But for tags like 7411, 7412, which are also from the quarry, she describes them as, what did she say exactly? They contain calcined human bone. And I think she also mentioned both human and non-human bone. The fact that she lists that as having calcined human bone is enough to say that Kratz knew that there were human bones in the quarry. And he misrepresented that fact to the jury. Whether that's going to do anything or not, this is the case law I didn't look at very closely. From the citations that were here, it seems like some of those cases were a little bit more like on point, like where it was a very egregious, like ignoring a previous statement that was given, where that prosecutor absolutely without a doubt knew, you know, what it said. This is a little bit more subtle, but it still is, you know, him saying that there are no human bones, and this report says there were. So I don't think it's quite as, like I said, as strong as some of these other citations she cited, but it's still on point. Please repeat your opinions during Eric Hosey's live. My kids are needy. You are killing me, Britton. Okay. I'll do whatever whatever they want me to speak to. Travis is here, so he'll know what I'm already talking about, so he can always ask me to repeat something if I need to. When is the state opposition due? Brian, were you here when I just talked about that? I just spent like a long time explaining when the state's response was due, or if it would be due. You're gonna have to go back and watch that because I just talked like for 5 minutes about that. Or Travis can answer it, actually, Brian. How much weight does Kratz blatantly lying to the jury carry? Well, the citations this is what I didn't get to look at very closely. She's citing out-of-circuit cases, which I don't, is not ideal. But she does have a United States Supreme Court case here, but she's citing 2 cases from the 9th Circuit, 1 from the 6th Circuit. Ideally, if you want a federal case, you want a 7th Circuit case because it's, like I said, you want one that's in your circuit, that's controlling in your circuit. More ideally, you want a Wisconsin case that's controlling. So that's a bit problematic. So I would say that it's not a very strong chance of winning on that. It's because it doesn't seem like there's any cases that are really backing that up there in Wisconsin. That's one of the things you have to look at. When you see a citation, you have to look at where it came from. Obviously, U.S. Supreme Court is always probably the best. Wisconsin Supreme Court would be second best. Wisconsin Court of Appeals, and then 7th Circuit. But when you get outside other states' opinions, are like the worst. They have like no precedential value at all. Other circuits, they can be considered, but again, you kind of rolling the dice there. It's not a real strong citation. Okay, so he's talking about those cases, and I will try to look into them. I don't know if I will or not. I don't know if it's that important to know how strong those citations are. I don't know if that she's going to win on that, but okay. Now we're getting to the disqualification of Judge Suckowitz, and I know there's been this huge movement about this petition and about asking her to recuse herself. People have asked me about the petition. Sign it if it makes you feel better. That's what I'll say. It's not going to carry any weight. It won't. But online petitions are great for raising awareness. That's what they're good for. Okay, they're not going to change anything. They're just not, especially when you have signatures from everywhere. Number one, the signatures have to come from Wisconsin, ideally from Sheboygan County, before anybody would care. And again, I'm not trying to rain anybody's parade or piss in anybody's Cheerios or anything like that. I'm just saying that's how petitions work. Petitions only carry weight in the jurisdiction of which you're filing it or where you're trying to submit it. So it's the same thing with the pardoning. When people are signing petitions for pardoning, or even for Brendan's law, or for Barb's law, it's called now. But for that, honestly, your signature doesn't carry weight if you don't live in Wisconsin. It doesn't. And I said it. I think it's good for people to sign because the more signatures a petition has, the more awareness it raises. But it's not going to change anything. Nobody is going to get rid of a judge. And I don't think the governor even has a power to get rid of a circuit court judge. I'm not even sure. I think the Supreme Court would have more. That's the executive branch. The whole point of having three legislative or three powers of government, branches of government, is that one does not have more authority over the other. So to have somebody from the executive branch to be the governor, removing a judge from the judicial branch is seriously stepping on some toes when it comes to your separation of powers. Pardoning is one of those exceptions under the executive branch, that they have the power to pardon a conviction, but they don't have the power to. Well, in some states they do, not in Wisconsin as of yet. They've never had the power to expunge a conviction or to reverse a conviction. They just have the power to pardon somebody, which is to essentially forgive them, but the conviction still stands. That would be a big fight for the judiciary. That's just like how the judiciary fights with the legislative branch about who creates laws. Okay, it's supposed to be the legislation that creates laws. The courts are supposed to just expand on laws. And yet sometimes the judiciary is overstepped and sort of created law, and then the legislation gets upset. So that's another whole issue, though. Sorry, I digress. But I'm just going to say that there is one way to get rid of this judge, and that is to get through the appeal. Kathleen already knows that. I was very annoyed when I found out she was going to try to disqualify the judge again, or ask the judge to disqualify herself. I was annoyed because she knows how to do it. Just using common sense, it goes back to the same thing I said in my last video on this subject, was that, as I said earlier, this is the same petition. Just because they're different proceedings, it is the same petition. You cannot have two judges ruling on the same petition. It's judge shopping. That's exactly what the courts will call it. You don't like what this judge is saying, so you're going to go get a different one. You want a different one. It doesn't work that way. If this was a completely separate action, she might have a case, but it's not. Okay, so you're asking for two judges to rule on the same issue. Exactly. I mean, it doesn't matter that this is a supplement. It is still the same petition. It's the same action. And you can't have two judges ruling on the same thing. There would be another judge coming in and basically stepping on the other judge's toes, and that just doesn't happen in the judiciary. Unless a judge gets ill or it's unavoidable. That's the only time something like that would be allowed. It's not allowed just because. I'm going to get to that, though. And I'm not saying this. And this is where I will start again with my usual disclaimer. I don't like Judge Suckowitz. I don't like her rulings. Okay, I don't think her ruling on the original petition was in any way correct whatsoever. I may agree on certain issues that she has. Like I said, her ruling on the judicial substitution motion was actually correct. You know, it was correct. So just because I don't like her, though, you know, that doesn't mean that I'm going to lie about what the law says and what the reality of the situation is, okay? Because that's not fair to anybody that really wants to understand, should this be done? Could it be done? I know that everything about this petition, about wanting to get rid of this judge, is an emotional reaction. It is. And it's an understandable one, because this judge is ridiculous and nobody likes her. I get that. But an emotional reaction doesn't carry any weight with a judge or a court or any court at all. So the only thing that really frustrated me about the petition, I don't care if people want to sign a petition. It doesn't bother me. The only thing that frustrated me about it was that last year was when we had judicial elections. Now, granted, she ran unopposed, but if this had been happening before the ballot came out, you know, like when she first ruled against Steve in October of 2007, when she wasn't reelected until April of 2008, maybe something could have been done. If people were aware of how bad this judge was and the rulings and how many times people requested to substitute her, then maybe something could have been done, because that's where we have our power, in our judicial elections. Maybe she could have been, you know, maybe somebody would have ran against her then. If they saw that there was this huge movement to get rid of her, nobody said anything then. There was no petitions then. She ran unopposed. She got reelected. Now they're stuck with her. Plain and simple. There are ways to affect change, and we missed our opportunity. That was our chance, and now we're stuck with her for a while again. Yes, Youngblood is an Arizona case, but I mean, Youngblood is an Arizona case, but it was decided on by the U.S. Supreme Court. What about Fassbender, Wiegert? I don't even know what they're not even mentioned in this motion, Des. What is the difference between the different circuits? There's no difference other than they just handle different regions. That's all. So the 7th Circuit handles Illinois, Wisconsin, Indiana cases. And then usually whatever decisions are made by your circuit are controlling in your area. Doesn't mean that they can never go outside the circuit for decisions. And the circuits are supposed to try to be consistent. And that's usually when the U.S. Supreme Court will step in, when you have a lot of like discord among the circuits with specific issues. If one circuit is ruling one way on an issue and another circuit's ruling another, that's usually when the Supreme Court will take a case, because they need to they need to reconcile the circuits, that everybody's kind of on the same page. Well, Steve and Sue Manitowoc again, actually the county, not the city, but yeah, of course you would. And a lot of other people. I'm not going to get myself in more trouble than I already have with some of those things, because people get mad at me when I criticize things. I'll be voting on April 2nd. Yes, we have judicial elections on April 2nd in Wisconsin. So if you're in Wisconsin, get out and vote. Supreme Court justices are actually on the ballot. So do your homework. If you aren't familiar with the judges, just, I mean, go to Ballotpedia, if anything, and read their bios, read what they stand for, you know, look up some cases, whatever, but try to make an informed decision. But yeah, our judicial elections, it was a 17% turnout, or 16% turnout last year. It'd be nice if it was a little bit better. But anyway, we're moving. Okay, so we're going back to the disqualification now that I kind of ranted about it. Okay, so Kathleen's bringing up the code of conduct. Okay, the first thing about this is that the code of conduct, this is a guideline for how the Supreme Court is saying that judges should act. It's a code of conduct. This is how you should act if you are a judge. These aren't the rules that are like you'd have a violation, that they were in violation of a statute, or that's not what this is. These are just the rules of conduct that a judge should abide by. Okay. And that's actually covered in case law too. So I will get to that. Judges' recusal and disqualification is covered under Supreme Court Rule 60 and Wisconsin State Statute 75719. She doesn't bring up the statute at all, which is interesting. At least I don't think she did. I don't remember seeing it. What she did, okay, first of all, she brings up Judge Willis recusing himself, okay, from the civil case. Oh God, I'm already going over time. Okay, so Judge Willis recusing himself in the civil case. She says that Judge Willis recused himself from the Halbach civil suit because he had presided over the criminal case, including the direct appeal and post-conviction process. Not entirely accurate. Okay, Judge Willis recused himself from the civil case on March 24th, 2006. That was after Steve was found guilty. I believe the guilty verdict was March 18th or 19th. I should remember, but March 18th or 19th, 2006. So less than a week later, Judge Willis recused himself from the civil case because he had presided over the criminal case. He had not yet sentenced him, and he certainly not sat through his post-conviction proceedings or any direct appeal at that point. Okay, why did Judge Willis recuse himself? Well, because in that situation, he had presided over a case until its conclusion. Okay, not just listed as a judge on the case at some time during the proceeding. He was the judge through the entire proceeding and there for judgment, and was going to be sentencing him. Okay, so that's why Judge Willis recused himself, because he had presided over the entire trial. But I just want to clear that up. That's not correct. It was, he recused himself after the guilty verdict, but prior to sentencing, and definitely prior to post-conviction proceedings and any appeal. Just want to make sure I cover that. And then she goes into the Supreme Court rules for 60. And like I said, I mean, you can read them; they sound good, whatever. But I said these are the rules of conduct that the judges are supposed to follow. They're not really meant to disqualify a judge. And again, case law will support that. So when it comes to Judge Suckowitz with the civil case, when she says she presided over the civil case, so she should be able to preside over anything else. Again, she didn't preside over it until its conclusion. She didn't make a ruling in the case. If she had ruled in favor of the Halbachs and had determined that Steve was responsible for Teresa's death in a civil proceeding, that would be different. Then she should not be presiding over any of his later proceedings. But she didn't. She barely even presided over the case. So there were like, I don't know, there were a handful of judges that were assigned to this case, and it got bounced around a bunch of different judges. She was actually assigned to this case. I didn't look up the date, but quite a while ago. I believe it was before even his last post-conviction. Anyway, if there was going to be any mention of disqualification for bias or conflict, it should have been then. Like I think she was already on his criminal case before she was assigned to the civil case. So it was like, that's when a motion should have been filed for recusal, because she's been presiding over both. And now, if anything, when Kathleen took over the case, then maybe she should have made an argument for asking her to recuse herself. She still probably wouldn't have won, just saying. But it would have been better to make the argument then, not wait till you're in the middle of the appeal and you don't like the judge's rulings, and so now you just want to get rid of her. The fact that she delayed, the only argument Kathleen has is that she delayed the dismissal of the proceedings, the civil proceedings. No court is going to say there is bias because of that. They have ruled there is no bias when judges have flat out said horrifying things about the defendant in front of them. For example, Judge Willis proceeded over the trial and he proceeded over his post-conviction proceedings. So again, if this is a conflict for Judge Willis, that should have been a conflict, but it's not. And that's even after Judge Willis said that Steve was probably the most dangerous individual who ever stepped foot in that courtroom. And he still presided over his post-conviction proceedings. Okay, that type of thing is not a conflict, and there's case law on that too, and I'll get to that. Then she goes on to bring up the Model Code of Judicial Conduct, specifically Rule 2.11. Okay. The ABA's Model Code of Judicial Conduct is a guideline. It's a suggestion. Many states adopt those rules. Wisconsin has not. Not that particular rule, at least. So she's citing a rule that Wisconsin doesn't even have. Wisconsin, and she knows this because she says right in the beginning, she says that although not strictly required by the Wisconsin Code of Judicial Conduct, not strictly required, not required at all. The Supreme Court rules that, or what I said, SCR 60 that she cites, that was their response to the model of conduct. They didn't say anything about presiding over other cases. And then she brings up an Arkansas case. What did I just say about states, cases in other states? Meaningless, okay? And in that situation, Arkansas happened to adopt that rule. But also in that case, let's say, forget about that part. In that case, the judge had presided over a separate proceeding that went to its conclusion. This judge had already ruled against the person in this case. And so they wanted the judge to recuse themselves on the next case. Again, it's a very different thing between being a judge that presides over a case that is dismissed and never has a trial, never has nothing. There was nothing ever presented in front of the judge versus hearing an entire trial and reaching the conclusion to it. And then she brings up, how Wisconsin tribunals in similar situations have determined that their disqualification from a criminal proceeding after having presided over a civil lawsuit involving the same subject matter is appropriate. Again, in the case she cites, Kohler, it's in the procedural history of the case. It has nothing to do with a ruling. It has nothing to do with anybody requiring him to recuse himself. It doesn't have anything to do with anybody requesting he recuse himself. In that case, this is exactly what it says in that citation. This is exactly what it says. After the civil trial was concluded, Judge Harrington held a status conference to the criminal case. He stated that because he had presided over the civil trial, he would withdraw from the criminal case. So this judge made that decision on his own since he presided to the conclusion of the civil trial, meaning he ruled in favor of one or the other, probably against the defendant in this case. He was not going to preside over the criminal case because it would at least be the appearance of conflict. Okay, so now I'm going to go to these citations so you don't think that I'm just saying this stuff, okay? And this is, again, disclaimer. I don't write the rules. I don't write the case law. I'm explaining them. Again, I wish we could get rid of her too, but the law doesn't support it being a reality. Okay, so statute 75719 governs disqualification of judge. I'll go through really quick. That it says a judge shall disqualify himself or herself from any civil or criminal action when one of the following situations occurs. When a judge is related to any party or counsel or their spouses within the 3 degree of kinship. third degree of kinship, I should say. When a judge is a party or a material witness during a proceeding, I'm just going to paraphrase these. When a judge previously acted as counsel to any party in the proceeding, meaning if you were the person's lawyer, you cannot then be the judge on their case. Kind of a no-brainer there. When a judge prepared as counsel any legal instrument or paper whose validity or construction is at issue. So if you were a lawyer that worked for the law firm that represented this person and you happen to write up something for the case and that's at issue, you can't be a judge on the case. When a judge of an appellate court previously handled the action or proceeding while judge of an inferior court. Okay, Travis, pay attention, because we just talked about this and I had it wrong. We just talked about this because since both judges who are in the appellate court or who are running for Supreme Court are on the appellate court, I had said that, well, then I thought that Lisa Neubauer, Judge Neubauer, presided over Steve's direct appeal. She was part of the panel that ruled on Steve's direct appeal. Therefore, if she wins at the Supreme Court level, I said that she would have to recuse herself. Not true. It's only in the situation of an appellate court judge who previously heard the case when they were a circuit court judge that would have to recuse themselves. Because this actually happened in my favorite case, Henley. Justice Roggenstock, or how you say her name, she presided over Henley's appeal and then presided over his, when it went to the Supreme Court. And it was allowed because it said that apparently justices have special rules. I don't know. But I read that right after I talked to you. So I wanted to make sure to mention that. So yeah, I'm glad this reminded me. When a judge has a significant financial or personal interest in the outcome of the matter. Again, kind of a no-brainer. And then this is the one that everybody kind of points to. It's 757192G. When a judge determines that for any reason he or she cannot, or it appears he or she cannot, act in an impartial manner. This is the one that's most important here because essentially under Wisconsin law, only the judge can decide if they could be impartial or not. It is not up to anybody else at all. Okay, it's very clear what it says. When a judge determines they cannot be impartial, they have to recuse themselves. It doesn't matter what anybody else has to say about it. Okay, and now this is some of the cases that I wanted to talk about. First off, the case that is instructive and expect the state to cite it. Remember this name, State versus American TV. That is the instructive case for this type of, for that statute, which is probably why Kathleen didn't cite the statute. It's weird that she just relied on the Supreme Court rules, which again is the ethics code. It's not where you find violations. I get to that too, but actually that's one of the first things I have here. It says that in State versus American TV, so they will still cite it, the Code of Judicial Ethics, which is what Supreme Court Rule 60 is, governs the ethical conduct of judges. It has no effect on their legal qualification or disqualification to act. Pretty cut and dried right there. It's saying it governs the ethical conduct of judges. It doesn't say anything about, has no effect on their legal qualification or disqualification to act. So it means that it doesn't have anything to do with disqualifying themselves. This is all from the same case. The basis for disqualification under 2G is a subjective one. Accordingly, the determination of the existence of a judge's actual or apparent inability to act impartially in a case is for the judge to make. Okay, the statute says it, and now they are just reiterating that, making sure that you understand. Because the basis for disqualification is subjective, requiring the judge's determination of an actual or apparent inability to act impartially, there is no standard to apply on review other than an objective one limited to establishing whether the judge made a determination requiring disqualification. Okay, I will explain what that all says, because that's a mouthful. They're saying again that it's subjective. It's up to the judge to decide if they can be impartial or not. The only standard for review, meaning the only thing the appellate court can look at when a judge makes that ruling. So if Judge Suckwitz rules, yeah, I can be impartial, no problem, and denies this part, the only thing the appellate court can do is make an objective ruling as to whether the judge properly considered it. Like, did you actually, at least take some time to decide whether you could be impartial? That is literally the only standard there is. And they can't determine whether she was impartial. That is for her alone to decide. They can only say, no, she said, I'm not even going to entertain this and whatever. She has to actually, they have to believe that she actually made an informed decision on this issue. That is the only thing. That is the only thing that they can do. So again, just wait for the appeal to conclude. That is how you're going to get rid of this judge, and the only way. It also says here, the seventh situation, which they're referring to 2G, requiring disqualification set forth in that statute, concerns not what exists in the external world subject to objective determination, but what exists in the judge's mind. Subsection G requires disqualification when a judge determines that for any reason he or she cannot act in an impartial manner. So again, when they're saying it doesn't concern what exists in the external world, like petitions. I hate to be on the nose with that, but that's exactly what they're referring to. No external source is going to determine a judge's ability to be impartial. And then some of the other citations, it says in State versus Harrell, it says, that statute leaves the responsibility withdrawal to the integrity of the individual judge or justice. To imply that the judge or justice of this state are not able to make such a determination honestly, openly, and fairly is a great disservice to the quality men and women who serve the state in a judicial capacity. So yeah, they're basically saying, if you try to do this, if you try to say that, you're insulting the judiciary in general by implying that they are incapable of being impartial. So again, this is coming from the U.S. Supreme Court. So not my rule, but again, what do you make? Okay, I'll read the rest of them. While an assessment of whether a judge appears partial might initially seem to be open-ended, this objective test, properly understood and applied, does not give litigants license to ferret out anything which might appear suspicious and use it as a basis for demanding a judge's disqualification. So those are both from State versus Harrell. So yeah, expect the state to cite both those as well, because it's almost like they're speaking to this motion, where it says that it does not give litigants license to ferret out anything which might appear suspicious and use it as a basis for demanding a judge's disqualification. You don't get more on the nose than that. And again, I'm talking about citations from our Wisconsin Supreme Court versus Kathleen's citation from an Arkansas court about a rule that we don't even have. So, I mean, and then let's see, there are a couple more. State versus Rodriguez. This is a Court of Appeals case. Absent a pervasive and perverse animus, a judge may assess a case and potential arguments based on what he or she knows from the case in the course of the judge's judicial responsibilities. Opinions formed by the judge on the basis of facts introduced or evidence occurring in the course of the current proceedings or of prior proceedings do not constitute a basis for a bias or partiality motion unless they display a deep-seated favoritism or antagonism that would make fair judgment impossible. This goes back to what I said about Willis, about why could he preside over the post-conviction proceedings, even though during sentencing in the trial, he said that Steve was the most dangerous individual to ever step foot in the courtroom. This is why. It says, opinions formed by the judge on the basis of facts introduced in the course of the proceeding, current proceeding or prior proceeding do not constitute a basis for bias. Seems crazy, but that's how it goes. So that was State versus Rodriguez. Oh, fun fact about that case. The cop on that case, as I was reading it, I was like, hey, I know him. The cop on that case was a kid that actually grew up down the street from me, and I went to school for my entire life, grade school, high school, who was later, after this case, arrested for official misconduct for soliciting a woman for sex while on duty and asking her to use cocaine. Fun fact. He's no longer on the force, thank God. But he was not, they initially charged him with sexual assault and something else, whatever. And he pleaded down to like obstruction of justice for lying about the encounter. That was it. Got a slap on the wrist. Not a shock. But anyway, I thought that was funny when I saw the name. I'm like, oh, yeah, I know him. And then, okay, just a couple more, then I'm done. Litke versus U.S. This is a Supreme Court, U.S. Supreme Court opinion. So SCOTUS. The judge who presides at a trial may, upon completion of the evidence, be exceedingly ill-disposed towards the defendant, who has been shown to be a thoroughly reprehensible person, but the judge is not thereby recusable for bias or prejudice, since his knowledge and the opinion it produced were properly and necessarily acquired in the course of the proceedings. So even though they express the fact that you're a reprehensible person, they can still preside over your proceedings. Also not subject to characterization as bias or prejudice are opinions held by judges as a result of what they learned in earlier proceedings. It has long been regarded as normal and proper for a judge to sit in the same case upon its remand and to sit in successive trials involving the same defendant. Something I pointed out when I talked about conflict of interest. I'm like, it's normal for that to happen. I don't like it. But it says it's long been regarded as normal and proper for a judge to sit in the same case upon its remand and to sit in successive trials involving the same defendant. And that comes from the Supreme Court, U.S. Supreme Court. Okay, so all that being said, again, don't listen to my opinion. I just read all the citations for you. And so you guys tell me, do you think she has any chance of getting rid of this judge? So, okay. Okay, you guys are welcome. Go ahead and call me crazy, but I think Judge will at least order an evidentiary hearing on this issue. Well, if anything, she has to order a response from the state. If anything, she has to, absolutely. Because you can't make a determination on this without finding out what the hell is going on with the state. Like, do you have this stuff? Why don't you? What happened? You cannot make that determination based on just what Kathleen filed. Okay, Eric Cozy's time just says 50 minutes. How long ago was that, Allie? I need to go get something to drink. Yeah, I've already been way over an hour. So I know he was planning on doing it at 8 o'clock. I think he was shooting for. If you were Judge S, would you want to preside on this? Sure, because I know I'm capable of being impartial. And I know the law better than she does, apparently. I don't know all law, though. But under what she, based on her ruling from the first petition, I know better about that, at least. She has so many people asking for a different judge compared to the other judges. No, it doesn't matter. Like I said, I just read all these citations that say that basically, we don't care what you think. No outside source is going to determine it. It is the judge and the judge alone who decides if they can be impartial. And if they say they can be impartial, too bad. Then you have to deal with it. Oh yeah, wait, no. Oh, maybe, so did I get the trial dates wrong? Yeah, probably. Okay, no matter what. Yeah, so was Steve sensing, oh God. Okay, so I said that Willis recused himself in 2006. Steve wasn't sentenced until 2007, correct? Yeah, I totally screwed that up. No matter what, though, it wasn't what Kathleen said. He recused himself while he was in the process of presiding over Steve's criminal trial. God, I'm sorry. I sounded really dumb there, didn't I? But no matter what, it's still better than what Kathleen wrote. Because he recused himself very early on, and that was before any of the stuff she said. Yeah, Justice is being weird right now. She's actually with my husband. She's kind of his companion right now that she's not feeling well. Okay, so Julie's saying that Manitowoc said they were recusing themselves from the investigation and they're investigating anyway. I wonder if in her mind the argument for Judge Angie to recuse herself has anything to do with that. I'm not suggesting no, it has nothing to do with that. It's two totally different situations. I said legally, Manitowoc did not need to recuse themselves. They did it, or they said they were doing it, but they didn't break any laws by not doing it. So, yeah, this is a totally different situation. Stretch as long as you like. Okay, it's 29 minutes now. Okay, that gives me a little bit of time. Hi, Stacy. You're coming in right at the end, but you can catch me over on with Eric Hosey in a little bit, in about a half hour, I guess. Okay, 45 minutes, he said still. So, okay, good. I've got some time. If there are any other questions, then go ahead and ask. Otherwise, I'm going to wrap it up. As usual, it took longer than I thought. I apologize for that. I'm sure I bore you guys to tears. Yeah, only like 60 people are left. There were like 100, over 100 at one time. I always get paranoid when that happens. I'm like, oh God, I bored everyone to death. I gotta stop talking. One question, Travis. Okay, go ahead. What part hit the ice? Just kidding. You know which part. Flat on my butt on the ice, and it hurts to sit. And then the next day, I fell on my knee. I fell on the ice again. Fell on my knee. Thanks, Sue. You have a question about Dodge? Should you wait to ask it? No, go ahead. Ask it now. Unless it's like really long and complicated. Yeah, at least you guys can rewatch. Thanks, Travis. I will be talking to you just in a little bit. I think she just brought up CX. Lacey asked if she brought up CX for any particular reason. I think she just brought it up because she was, again, trying to make an argument for the fact that there was some suspicious stuff over there in the quarry that would, lead to, make us believe or make people believe that something more could have happened there. I totally didn't word that well, but you know what I mean. Do you feel this motion was not as good as it could have been? No, I mean, I think the motion is good overall. There's just like the only thing, ignore the judicial substitution stuff, because like I said, that I don't even know why she included it. And yeah, I'm not a fan of that because, again, if you look at Wisconsin case law, she doesn't have a leg to stand on at all. So I don't understand the rhyme or reason to doing it at all. I know people suggest, well, she wants it on the record. Well, it's already on the record that she wants to substitute the judge. There's no advantage whatsoever to filing, to making these arguments to get rid of her. The only thing I don't like is her constantly bringing up the April 2007 preservation order, misrepresenting what it says. And not just because of her saying it, but because it gives the state an argument to win. That's what I don't like about it. Otherwise, no, it's a good motion. She did everything she had to do. I mean, she presented everything the way she needed to present it, and she's doing the best with what she got to work with, I think. I think that the Fallon letter would have been better to put in there. Oh, their justice is barking, but she's upstairs. So I think, yeah, I would have liked to have seen the Fallon letter in there, but it's such a minor thing overall, I guess. No big deal. Why are people claiming that KZ should have cited or quoted Dodge? Well, actually, she shouldn't have, because that goes completely against what she wants. Dodge was a case where they said, where the Court of Appeals ruled that there was no bad faith in destroying evidence, and they also ruled that it's the only case where there was any ruling on the preservation of evidence statute, and they ruled that yes, the statute. Well, no, they ruled he was procedurally barred, but even if there had been a violation of the statute, that there is no remedy, so that he wasn't entitled to any relief. So it's actually like the worst case. But the reason why she can't cite it is because it's an unpublished opinion. You can't cite an unpublished opinion. Neither can the state. So it's a meaningless case. But yeah, definitely shouldn't cite that case, because that's what the state would love to be able to cite it. But it's not precedential in any way, has no precedential value, and it can't be cited because it's an unpublished per curiam opinion. Have we seen the video of the flyover with the tire prints? I don't know. I haven't watched the video, what she released today. I have no idea what it shows. Okay, if it was new to Allie, then it was new because I didn't get to watch, and I didn't get to read all the affidavits, the new stuff that was added today. I just didn't have time. Do you think she's proven bad faith in the motion? I think she's made a good argument for it. Statistically, it's against her because, as she said, you know, there's no Wisconsin case. Well, she said there's no Wisconsin case that has ruled on the preservation statute, no published case, which is why she used the word published because of Dodge. The state can't cite it. Andy just asked, like, if it's published, what if the state cites it? They can't. It's an illegal citation, so it would be meaningless. I totally lost my. Has she proven bad faith? I think she's made a good argument for it, but in addition to there being no Wisconsin cases on the preservation statute, there has never been a Wisconsin case where a court has determined there was bad faith when it came to disposal of evidence or destruction of evidence. They've always ruled that it was inadvertent, it was due to neglect, it was just accidental, it was a mistake. And some judges have had a problem with that. They've said that short of a law enforcement officer getting on the stand and saying, yeah, I did it on purpose, it's hard to prove bad faith. But I think she's done all she can. But statistically, it's just not in his favor no matter what because of that. If we are talking of a new trial, are we thinking years from now? Possibly. Yeah, possibly. Because no matter what happens, even if all things go well, and Judge Suckowitz orders a hearing and rules in Steve's favor and overturns his conviction, if we've learned anything from Brendan, that doesn't mean anything. It can be appealed for a long time, and it would be 18 months probably from that time before the Court of Appeals. Well, no, it'd be maybe up to 18 months before a Court of Appeals made a decision. At least a year, and then it would go to petition the Supreme Court, and chances are they wouldn't hear it. So yeah, so even if the Court of Appeals rules in Steve's favor, that's 18 months from now, and then you'd have to set a trial date for a new trial, wait for the Supreme Court and the new trial date. So yeah, it actually could take up to 2 years to get a new trial. Okay, I think I'm gonna wrap it up. Oh, Georgina, you just came in. Well, I'm wrapping it up now, so you can just start. You can watch it now from the beginning. So thanks again, everybody. Sorry it took longer than planned. It always happens. I don't mean to. Okay, God, you guys keep asking questions. In addition to your comments about bad faith, you believe Fallon not mentioning disposal can help in that regard? Well, yeah. I mean, the fact that he said he agreed to test it, you know, even though it didn't actually, the testing didn't happen because of the circuit court ruling, it does suggest bad faith that he agreed to test something that he didn't have. But if he says, I forgot, then they could just say, well, he just forgot that's what they did, and too bad. You know, it wasn't bad faith. It was just, you know, he just forgot. No, it can't be cited, period. You cannot cite oh gosh, Andy, who is saying these things? Please don't tell me Reddit, because oh my God, like there are certain people on Reddit that should not talk about the law ever, and they do. And no, it cannot be. You can only cite an unpublished case if it is authored by a specific judge. In the case of Dodge, it's a per curiam opinion by the court. No individual judge authored the opinion. Therefore, it cannot be cited. The only other time it could be cited is if it was involving claim preclusion, which is the procedural bar issue, and that is not the case here. So there is no circumstance which they can cite that case, period. So no, they can't use it. They can't bring it up. That's why when you search for Dodge using any type of, if you, like Travis will tell you, if you use Westlaw, use anything like that, and you try to look for cases that have cited it, you won't find any. There aren't any because it can't be cited. Okay. Hi, Lynn. Love you too. Okay. Okay, you guys are welcome. Certain forums on Reddit can only talk about Dodge, cats, and people's age. That's funny, Sue. I'm not knocking Reddit. I mean, there are a lot of good people on there. It's just sometimes. Oof. Okay, I gotta go. So I need a break before I do Richard or Eric Hosey's video. Oops. Okay, so I'll see you guys later. Have a good night.